Hi viewers, you are well aware that I am Dr. Jetling Ellosa, running a YouTube channel called Law Speeches, and my channel is available in the three languages English, Hindi, and Telugu. So I'm regularly posting my lectures on various aspects of law as well as the world affairs. And today we discuss the important judgments passed by the rendered by the delivered by the apex court of the land, the Supreme Court of India in 2024. As you know that we passed the 2024 and we are in the January of 2025, and the Constitution of India provides that the Supreme Court of India is a final authority to interpret the constitution or to any law of the land, and whatever finding it makes, that will binds upon the all the courts in entire territory of India. So in every area the Supreme Court has passing rendering the innumerable judgments. No other court in the world has passing such a judgments as that of our Supreme Court. Thousands of judgments have been coming, and there are some judgments are there which the law is interpreted in such a succinct manner, and a new law is being created. As Justice Gray once remarked that who makes the law? Generally, we know that legislatures are only makes the law, but in the Justice Gray opinion, not legislatures, it is the judges who makes the law. That is maybe partly correct, because the judges interpret the law which are available in their domain, and while interpreting, the judges and advocates, they interpret in such a way a new law is coming. So we are not going in depth of that. I am confining to the important judgments which are passed by the rendered delivered by the Supreme Court of India in 2024. The first judgment, that is a important judgment I am referring, that is a Rasool versus Union of India. This is also be called as a Bilko Banos convict case. So two bench judges of the Supreme Court, two judges, have been quashed the Gujarat government's order in releasing the 11 convicts who they are going for life imprisonment in Bilkas Bano case. As in 2002, during time of Gujarat riots, there was Bilkos Bano was gang raped, and the courts have been convicted them to life imprisonment, and they are undergoing the life imprisonment. While they are undergoing the life imprisonment, the Gujarat government has made an order providing the remission to them. So that act was challenged in the Bilkos Bano's case. The Justices Nagaratna and others, they, they remarked that they quashed the order which has been pronounced by the released by the Gujarat government in quashing the remission, in the providing the remission to the such 11 convicts. The second important case, that is the which the Supreme Court has rendered the judgment, that is the Association of Democratic Reforms versus Union of India. The five justices have discussed the validity of the electoral bonds. You know, the system of electoral bonds were introduced in India in 2018. So, by electoral bonds, the individuals, companies, and the corporations have donating the political funding to various political parties, and such donations cannot be revealed to anybody, which even they are not covered by the under the Information Act of 2005. So that kind of donations may be leading to a kind of a corruption, quid pro quo. So the Supreme Court on 15th of February of 2024 unanimously held that voters have the right to know what are the donations the political parties have been receiving, and the system of electoral bonds is not good for democracy. That should be disbanded. That was the opinion rendered by the Supreme Court of India. And Supreme Court also directed the State Bank of India, which have been collected the donations, to release all the information pertaining to the such donations, and asked the Election Commission of India to put it on their website, because right to information is a paramount, and the political donations may leading to the mass corruption in the political system. So that was because of the judgment, the electoral bond system was banned. And the third important judgment of 2024, that is the Arvind Kejriwal versus Director of Enforcement. So the former Chief Minister of the Delhi, Arvind Kejriwal, was arrested in Delhi's liquor policy under the PMLA Act of 2002, that is the Prevention of Money Laundering Act. So there was allegation is there against him that he influenced the making of the policy, and where on account he got the huge amounts, the money laundered by him. And Supreme Court has stated that the Money Laundering Act provides stringent procedure, but it has been stated that the Kejriwal Arvind was a politician and he is a chief minister, and he was under arrest and judicial custody since long time. So trial may take much more time. So a bail can be granted to him. So this is one principle has been innovated by the Supreme Court in this case, that is the bail is the rule and the jail is the exemption. So where on account there are many political leaders may come out, like Kavita also arrested in that case, and she came out with the bail, and Manish Sisodiya, another AAP party leader, was also arrested. He also came out because of this uh, judgment, that is a bail is a rule and jail is an exemption. Then fourth important case that we have to know, that is the state of Punjab versus Davender Singh. The this case pertains to validation of the subclassification of the SCs and STs. and 7 judges, they given a far-reaching judgment which affects upon the society. So in which the judges have been stated that subclassification is permissible under the Constitution of India, under Article 342 of the Constitution of India, where the SCs and STs reservations have been provided. And the Justice Chandrachud, the former Chief Justice of India, he, he led the judgment, and 6 by 1 majority, uh, it has overturned the earlier judgment, that is a EV Chinnaya versus Union of India, which was passed in 2004, which prohibited the subclassification of the SCs and STs. So this, and one more aspect, the judgment has provided that the subclassification can be done by states. The states have the right to subclassify the can carry out the subclassification. And number fifth important judgment, that is Mineral Area Development Authority versus Steel Authority of India, and State of UP versus Lalto Prasad Vaish. The judges, the full bench of the Supreme Court, dealing with the matters pertaining to the taxation of mines, minerals, and regulation of industrial alcohol. So in this case, there is a conflict was there between the central government and the state government over the who can tax the mines and minerals which they are excavating, and the matter was went up to Supreme Court, and the 8 to 1 majority, it was held that the parliament has the power, but it should not extend taxing upon the state power. So state also has full power. So state, because when it is there within the ambit of the state, state can make a law, and central cannot make enter into domain of the state law. That was a decision rendered by in this another landmark case. The the sixth important landmark judgment of 2024, that is the Just Rights for Children Alliance versus S. Harris. This case pertains to POSCO Act, possessing of child pornography, punishable or not. The two-judge bench has stated, I held that if a person is possessing any sort of child pornography, he can be prosecuted under the POSCO Act. The Justices J.B. Pardiwala, who objected to this sort of decision, but the but as and today law is made by Supreme Court stating that nobody is allowed to possess any sort of child pornography. That was a gist of this judgment. Next, seventh important judgment, that is the Citizens Assam Accord. The validity of Section 6 of the Citizenship Act was discussed, and 5 judges bench has been interpreted the Citizenship Act of 1955, where on account the Assam Accord of 1985 violated the Article 11, 14, 29, 326 and 355 of the Constitution of India. So to mitigate the tension which was there in Assam state, there was a Assam Accord was made in 1985. So because of this Assam Accord, the many illegal immigrants who came from Bangladesh were given citizenship in Assam. So that was a question in this case, and the judgment upheld the section 6A by 4 by 1 majority, rejecting the claim that the provision of the dilution of the Assamese culture or language does not amount, it is nothing but may not be a external aggression because of to maintain the peace and harmony in the state of strife tone Assam Accord was made. So that was been accepted in this judgment. Then there is a another eighth important judgment which was passed in 2024 by Supreme Court of India, that is the Property Owners Association versus State of Maharashtra. The, in this case, the private property rights have been clearly elaborated by the apex court of the land. The nine judges who sat to hear this case, whether we have the right to property or not. Earlier, we have right to property was fundamental right till 1976, but now it is only constitutional right under Article 300A of the Constitution of India, whether the state can take our private property for public purposes. The question came to, and whether and in this case also, whether Article 31C is continued to exit or not, after Minerva Mills versus Union of India case of 1980 that has been discussed, and and also the Article 39B of the Directive Principles of State Policy, which was stating that material resources of the country belongs to the state. That also been discussed, and the on 5th November of 2024, nine judge bench unanimously held that Article 31C is continued to exist in in the in the constitution, and so on this account, this the government merely stating that the property it needs cannot take the private property. It should have to show extraordinary things necessity to acquire the public property, private property, without saying that we need for the public purpose is not sufficient. The government should show extraordinary circumstances to take the public property. That was clearly stated by the Supreme Court by the judges 8 to 1, they held it. And the ninth important case of 2024 is the Aligarh Muslim University versus Naresh Agrawal. The case pertains to minority status of the Aligarh Muslim University. So Aligarh Muslim University was the oldest university founded way back by the about 100 years back. So whether the university is to be called as a minority institution or it is a general institution, the question in this case. So the university was founded by Aziz Basha, who claimed that it is a minority institution, who claimed it minority institution under Article 300 of the Constitution of India. So under Article 300 of the Constitution of India provides the minorities have the right to establish institutions and run such established associations or institutions. Then the in parliament at that time, means legislature which was there at that time, made a Aligarh Muslim Act of 1920. And the in this present case, the 4-3, the judges are opined that institutions incorporated by legal instrument can have a minority status if the founder was a person from the minority community. It also put down specific parameters to determine the minority status of any religious or linguistic education institution established under Article 30 of the Constitution of India. So it should have to be founded by minority, then only it be called as a minority institution. So, but here it is not there. So it is held that the earlier decision was overridden by the Supreme Court in this case. And tenth and last important decision, I am only taking the top 10 decisions of the 2024 of the Supreme Court. The last decision is the review of directions in the matter of demolition of structures. So the case pertains to guidelines to curb the illegal bulldozer demolitions. So bulldozer demolition is now became a popular in some states like Delhi and some other states, Delhi and Uttar Pradesh. So they bulldozing, they're destroying these houses. Even in Telangana also we have the Hydra. Recently we are hearing since 2 or 3 months. The Hydra is destroying, demolishing all the illegal structures which are there in the government lands and the nalas and other water ponds. So whether that power is there vested, the forcibly the property can be destroyed without following the due process of the law or not. So this case, two-judge bench has held that this matter was in Jahangirpura of the area, and there was some sort of Hindu-Muslim rights took place, and the in Jahangirpura of this area, the to curb the communal violence, the, their government has started destroying the some house properties. So the matter went before the Supreme Court, and Supreme Court has clearly stated that bulldozer politics are not allowed. Bulldozer activities are not allowed. So it is against to the fundamental rights. If the government wanted to take the to do something, it has to follow as per the provisions of the law. Without following the provisions of the law, it cannot do this kind of activities. It is against to the rule of law, against the principles of natural justice, and all the principles of natural justice should be followed. Uh, and then it is a duty of the government to follow the principles of natural justice, duty of the state to follow. So these are the some of the 10 top judgments which I collected, and maybe some more judgments are there, but I'm only quoting the 10 judgments of the Supreme Court of 2024. And I hope that you got some sort of knowledge from my lecture. And once again, I request all of you to subscribe to my channel that is titled as Law Speeches, which is available on the YouTube platform. Just type my name as a Jetling Ellosa, Jetlingyellosa. Then you can get this my channel. My channel is available in 3 languages: Telugu, Hindi, and English. So I request all of you once again to subscribe to my channel. Thank you for watching my video.